Chasing overdue payments is a major headache for any business owner in Oklahoma. But what if the law let you collect the debt and your attorney's fees? In many Oklahoma cases, it does. And for construction, the law mandates a steep 1.5% monthly interest penalty on late payments. Oklahoma law provides a specific toolkit for businesses to legally collect what they're owed. We'll show you the deadlines, the fastest courts, the financial power you hold, and the mistakes that could cost you. Before court, your case is won or lost right here. Weak records of contracts and invoices are why businesses fail to collect. Time is not on your side. The probability of collecting a debt plummets with every month that passes. Your first official move should be a formal demand letter. It is a legal signal that courts view favorably. But even with perfect records, there's a hard legal deadline. How long do you have before you lose your right to sue? This is the statute of limitations. In Oklahoma, it's 5 years for written contracts, but only 3 for oral agreements. Here's a critical twist. If a debtor makes a payment or promises in writing to pay, that restarts the entire clock. To maximize recovery, the work starts early. Oklahoma law is clear. Interest or late fees must be in your original agreement. A major exception is the Prompt Payment Act. For construction, 1.5% monthly interest is mandated, contract or not. So you've done everything right, but they won't pay. What is the fastest legal path for most small businesses? This is Oklahoma's Small Claims Court, designed for speed. It has a $1,000 limit covering many business invoices. Its key advantage is a state law mandating your case be heard within 60 days. This stops debtors from dragging it out. But there's a catch. This tool is for you, the original creditor. Third-party collection agencies are generally banned. Imagine, you have up to 5 years to act on a contract, and once you do, you get a hearing in under 60 days. A powerful combo. Now let's discuss a specific pressure point, the bad check. In Oklahoma, writing a bad check isn't just a civil issue. It can be a crime with fines up to $5,000 and even jail time. This means your demand letter for a bad check carries the implicit threat of criminal prosecution, making it very compelling. Small claims is great, but for debts over $10K, you need a lawyer. This brings us back to the big question: who pays? The standard American rule means each side pays their own legal costs. This can make suing seem less appealing. However, Oklahoma Statute 12-936 creates a huge exception, letting winners recover attorney fees for service or goods disputes. But procedure matters. For bad checks, you only recover attorney fees if you sent the demand by certified mail 10 days before suit. Another point is, who is collecting? As the original creditor, you are not subject to the federal FDCPA, giving you more flexibility. Hiring an agency saves you time, but remember the trade-off from earlier? They lose access to the fast-track small claims court. Let's put it together. The 5-year statute of limitations gives you a long runway, leading to a 60-day small claims process. Combine a contract with interest terms and the statute allowing attorney fee recovery. You can now pursue the full amount plus costs. This creates a clear path to winning a judgment. But a judgment is paper. How do you turn it into actual money? This is where post-judgment collection comes in. Oklahoma law lets you garnish wages, levy bank accounts, and place liens on property. So, how do you get paid? By using the court's power to legally seize assets. These tools make the entire process worthwhile. From demand letters to attorney fees, Oklahoma law provides a clear roadmap for collecting what you are rightfully owed. Remember the keys. Document everything, act before the deadline, and know your right to recover interest and attorney fees. Stop letting unpaid invoices be a cost of business. Use this knowledge in Oklahoma's legal system to protect your bottom line.